the records that we're looking for faster. Other tools that are available to us now with review platforms that we use, litigation support tools, include exact duplicate and near deduplication identification, email threading, visual analytics, and you can see the list, conceptual clustering, predictive coding, and machine learning. So we're going to talk about all of those different tools. Using these has really become critical due to the large number of records that we are seeing in so many of our cases now. And you'll have heard me speak, if you joined the earlier webinar, about starting off cases that had 20,000 records or a few boxes of documents. When you receive calls now from clients when they're talking about hundreds of gigabytes or terabytes of data, or even 10 gigabytes of data, we're still talking about, we're in the world of tens of thousands of records. And these cases really need to be approached differently than the traditional linear review, when we could flip through a box of records one by one, or you could actually plug a USB stick into your computer and look at emails one by one. When you're dealing with these large volumes of electronic records, those days are really gone. And in terms of volume, though, just to be clear, when we had 10 or 20,000 records, that's, it's not the millions of records, but you can still take advantage of the tools that I was mentioning that are listed on the slide in front of you. TAR has really been the development of technology to assist with managing, expediting, and reducing the cost of reviews. So you can use it at those different levels. Even if we have 10,000 records, we still want to organize those 10,000 records. We may want to use email threading or near deduplication identification to pull together similar documents, because that will expedite the review. So you don't need these cases with hundreds of thousands of records. TAR, though, is not just the tool, it's also the process that's developed to support the use of the tool. And frankly, that is the most critical part. Through the use of computer software to assist with the legal review, although the use of the software is not new, what is new and what we're going to talk about is some of the linguistic technologies that are now being applied to streamline the process. So when you're using the technology and implementing any technology, what is critical is that you understand how the technology works, how to use the technology, when to use it, and how to validate the results that you receive. And that we're going to hopefully work through with you in the next hour. But without all of those steps, any of these different types of technology will not necessarily work the way that you think they're working. And we've heard anecdotally from other people, well, we've tried predictive coding and we didn't like our results, it didn't work. And generally, we don't think that that's about the tools, because the tools are available, and I think it's really about how understanding the tools and how you use those tools. Just going back to how you use the tools, think of a basic example, and you're using keyword searching, and you take the search terms and you run them, and they result in 10,000 records being identified by the search terms in a collection of 40,000 records. You can then say, great, I only have to review 10,000 records because that's all the search terms selected, and I can set aside the other 30,000 records and exclude them from the review process. The problem with that is you haven't validated your results, and you have no idea if your search terms worked or they didn't work, and if they were identifying the relevant records. So to truly develop a process around using search terms, what you need to do is, in addition to reviewing the 10,000 responsive records, you need to sample the 30,000 records that were excluded from the review set to validate and confirm that there is nothing in them that's relevant. Then you validated the results, validate the search terms, and you can proceed to review the 10,000 records. Sedona Canada Principle 7 tells us that a party may use electronic tools and processes to satisfy its documentary obligations. So that's great because it gives us that in Canada, it gives us a guideline and a best practice and an okay that using electronic tools is acceptable. Unfortunately, we don't, when we get into the case law section, we don't have a lot of case law supporting that. When to use TAR, just as a background, I talked about large data volume. So that's one time when you want to use TAR. Another time is when you have a significant number of custodians and you can't identify a group of priority custodians, when the issues outweigh the technology costs, when basic keywords are not working well, is another really good opportunity for using TAR. When the data is text-based with recognizable languages and characters, when you have strong OCR quality for digitized images, clear search intent. So you know what you're looking for, you know your case, and you understand what you're looking for through the records. Then you might want to use conceptual categorization in that case. And when you also have, another good time to use TAR is when you have an informed and sophisticated client and case teams who say, we're ready to use this technology and we want to use this right. So I'm going to now turn it over to Chuck Rothman to actually explain to you predictive coding and machine learning, and those are sort of two of the new technologies that are being adopted by Council.
All right. As Susan mentioned, all of the TAR techniques involve both technology and process, and predictive coding and machine learning are particularly process or workflow oriented. It's not just an easy button that you can push. You need to follow a workflow in order to get the results that you expect to get. So being a workflow, there's a number of steps involved. Now before I go through the steps, I just want to briefly cover what the software is actually doing under the hood. It's important to understand, at least at a high level, what's happening. Essentially, what happens is the system analyzes the contents of each document, all the words in the documents. When a number of records are coded as relevant or responsive, the system tries to figure out what common language is used between them on the assumption that the commonality between the relevant documents will be an indication of what's relevant. So as I'm going through the process, think about the machine is looking at the words. And what that means is this technique only works with documents that have paragraphs in them. It won't work on things like spreadsheets. It won't work on documents like CAD drawings. And obviously, it won't work on pictures. So the first step in the process is for a subject matter expert, which is someone who's very familiar with the matter, such as a senior associate or a partner, identifying a small set of relevant records, and this is called the seed set. They can identify this set using any of the other TAR techniques. You can run keywords, you can use conceptual categorization, you can even take documents that you've already compiled for preparing the pleadings and use those as the examples in the seed set. Depending on the review platform and the software incorporated into it, the seed set can be anywhere from 500 to upwards of 1,000 records. At the same time, a control set is created. What the control set is that the system will randomly pick somewhere between 1,000 and 2,000 records and have the subject matter expert code them either yes, it's relevant, or no, it's not relevant. And then that's used as the gold standard for when the system is later on predicting relevancy. It compares it back to the control set to see how accurate it is. So once the seed set and control set are created, the system will create batches of between 50 and a couple of hundred records and have the subject matter expert code them. At the same time, the system will predict what the subject matter expert is going to code. So for every one of those 50 documents in the batch, the system will predict ahead of time whether the subject matter expert will code them as yes, relevant, or no, not relevant. Once the subject matter expert finishes that batch, the system will compare its predictions to what the subject matter expert actually coded, and if they match, then the system says, okay, I'm done, I know enough, and I can make accurate predictions. Typically, that won't happen the first time around. And so what happens is this process is repeated over and over again, maybe 3, 4, 5, maybe up to 10 times, until the system gets enough information so that it can make accurate predictions. Once that's done, the system is in a position to be able to rank all of the unreviewed records. So it can rank them from 100% as most likely to be relevant down to 0% as least likely to be relevant. And it can, essentially, you can take this ranking and order the records for your review. So you can say, I'm going to start reviewing the most relevant records, and I'll work my way down. At some point, the reviewers will get to batches where all of the records are not relevant. And because these records have been sorted, all the records following it, based on this assumption, are not relevant as well. And so at that point, a decision can be made to say, let's stop the review because we're just wasting our time. But you just want to be sure that there isn't anything left in the unreviewed pile that's not relevant, and so you can validate it. And the way this validation works is that you take out a sample of the records from the unreviewed pile, typically 1,000, 1,500 records, and you review them to see if there's any relevant records in it. If there's no relevant records found, then you know, statistically speaking, that you finished your review, you found all the records. Now, I said statistically speaking. Statistics and probability play a big role in this whole process. You're not reviewing all of the records, and so the system needs to be able to extrapolate from the small subset that you're reviewing to apply it to the entire collection. It's similar to the way that Gallup does polls during the election, although it's a lot more accurate than Gallup is. And when Gallup does polls, you hear things like, this survey is accurate 19 times out of 20 within plus or minus 5%. Those are statistical values. The 19 times out of 20 is the confidence level. Basically what it's saying is, if I do this same survey or sample 20 times, I know for sure 19 out of those 20 times I'm going to get the right results. Now, you're not going to know which one is the number 20, but it gives you a level of confidence in the results. And within plus or minus a certain percentage means that the number I get, if I pull out a sample of records and I find that half of the records are relevant and half of them are not relevant, then I can say within the entire collection, 50% of the records are relevant, but it's plus or minus a little bit of number. There's a little bit of accuracy in there, and so typically you'll get a range. So I could say between 45 and 55% of the records are relevant. And that's your lesson on statistics. Now, machine learning.
You know, it's interesting that in the lesson on statistics, though, because we were asked yesterday on a call with the client, you know, what our opinion was as to what confidence level and the margin of error to use. And there's a standard that is used in a lot of the litigation, but which is a 95% standard and a margin of error of 2.5%. But we've had some clients who say we want 99% level of confidence, and that's fine. But what I think from a legal perspective is important for you to know is you're not going to achieve perfection, and you can't expect to achieve perfection. What you're looking for is something that's reasonable. And generally, using predictive coding, what is considered reasonable is a 95% confidence level and a 2.5% margin of error.
And not only that, because we're dealing with probability and statistics, and there is a very slim chance that when we pull out a sample and we get the results, they are not representative of the entire collection, the process incorporates multiple checks. And that's why in the previous example I just showed, at the end of the process, even though the system said there's no more relevant records, we still pulled out an additional sample and validated it ourselves just to make sure. So we're taking into account the unlikely event that we could be wrong and doing double checks.
And frankly, with that validation and sampling the excluded records, even when we do find, let's say, for example, less than 1% in that collection that are relevant, what we'll do is we'll look at that 1% and we'll say, why are they there, and what they're relevant, why were they missed? And sometimes it can help us look for other records and modify our process. So we're not just, you know, conducting that validation and then saying, well, there's less than 1%, we can ignore it. We're saying there's less than 1%, and statistically we're comfortable with that. It's legally defensible, but we'll also use the information to perhaps look for additional records.
Okay, we just had a question. What if you validate the results and you get a high number of relevant records in your validation? Well, what that means is this is the rare instance where the statistics actually failed. And if that's the case, if you find that you've reviewed and you're getting batches of no relevant records, and then you do a validation and find you have a lot of relevant records, then you have some problem. You may have to go back and start over again, or, as Susan said, you can look at the records and see why these particular records are still in the unreviewed pile. They may be totally different than the records that were used for the training. Now, machine learning is an evolution of predictive coding, and that's why it's sometimes referred to as TAR version 2.0. And the way it works is very similar, but there are some significant differences. You create a seed set the same way as before, but then what you also do is create a sample of the records and review it to see how many records you expect to find that are going to be relevant. So if you sample it and you find 50% in the sample are relevant, then you can say 50% in your collection are going to be relevant. The computer makes a prediction based on the seed set and immediately ranks the records and creates batches for review. Those are reviewed, and then that information is fed back into the computer where it makes more predictions, finds more relevant records, and batches those out for review. So you sort of skip the training step and you go right into review right away. And this goes on until there's no more relevant records found by the computer. And then you validate the system the same way as before. And if you don't find any more relevant records in your validation sample, you can say, we're finished. The advantage of this version 2 of predictive coding technique is that it generally results in about 1/3 less records having to be reviewed compared to predictive coding. Now I'm going to turn this back over to Susan, and she'll talk about ensuring that this process is legally defensible.
So any type of technology-assisted review is based on a process that uses computer programs. And although the programs can undergo exhaustive testing, it's still always possible that unexpected results can occur, and that can be for a multitude of reasons, including it's a unique collection. Therefore, in order to measure the effectiveness of the exercise, some test of the results needs to be defined, and this validation process is often ignored in the rush to use this new technology. So at the highest theoretical level, and we're going back to a bit to statistics, the best result would be 100% of the relevant records are captured and 0% of the irrelevant records. However, in practical terms, results needs to weigh the accuracy against the effort required to get there. And so there's a cost-benefit analysis. So how do we actually measure the results? And more importantly, for the judges in these cases, how can they be compared? And the answer to this lies always in the process. So what is critical is consistency and adopting a consistent method for selecting a sample and analyzing the results. And the consistent method should not only be consistent within a given subset of records, but each matter should have a set of electronic records with its own characteristics based on record content and other factors. And so as you're going through a project or a file, the approach to the records must be consistent. So if you're adding more records in, you must adopt a consistent approach. And then you can apply it throughout. So there's basically 2 ways to go about validating any result. And one would be to test the entire population, and the other is to sample it and rely on the statistics. So going through 100% records is what we used to do manually. And of course, there's still the factor of human error, which I think Chuck's going to talk about a bit later. But it's not possible when we're dealing with tens of thousands of records, and defeats the purpose of the whole exercise. So that leaves us with sampling. And so what's the best way of sampling? When it comes to sampling, there are two ways it's generally used based on what one wants to achieve. And the first is utilized to determine the makeup of a collection when nothing about it is known, and that's called survey sampling. And the second is used to prove an assumption about the makeup of a collection, which is assumption sampling. And both of these methods rely on basic statistics to confirm what is found in a sample is the same as what would be found in every record examined. However, the approach is different. And I don't want to get into them, but too much detail, but survey sampling is what Chuck talked about, which is the election campaign type sampling. And it involves selecting a random set of elements, evaluating them against the set standard, and measuring the relative percentage of the result. And this is used regularly in e-discovery. Assumption sampling is typically used differently in manufacturing, and it was used historically to determine the level of defects in a product. And it's used less often in e-discovery. However, it can be used to validate a set of records that have been culled from a larger collection based on some criteria. So you just, I mean, Chuck, I think, about to interrupt me, but I mean, when you're thinking about it, you want to try to determine which type of sampling you're going to be using.
And the reason why you want to do that is because assumption sampling requires you to review a lot less records than survey sampling. And so if you want to keep the number of records that you actually look at down, you should really look at what your goal is and decide on the method to use.
And in e-discovery circles, we will typically use survey sampling, and it's most often discussed because the implementation of it, the process of it, is much easier than with assumption sampling. So I'm going to move on and talk a bit about some of the case law now. And unfortunately, unless somebody wants to shoot in a question or an email and correct me, we've not been able to find any Canadian decisions that talk about the use of tar, but there is a lot. There was a developing body of case law in the U.S. and more recently in the United Kingdom. So the sort of seminal case was De Silva Moore, which is, you'll see the citation for it on the slide. This was a gender discrimination case. It involved both parties were advocating the use of a specific type of technology to assist in the review. In this case, though, one party wanted to use the technology. The other party was opposed to the technology. The defendants came to the table with the proposal to use predictive coding to locate relevant records, and the opposing party disagreed with the approach. The De Silva Moore plaintiff felt that using predictive coding would not be as reliable as doing a traditional keyword culling and eyes-on review. And it was really the first decision, the first time a U.S. court affirmatively approved a party's use of predictive coding and ordered that it proceed. And from there were a series of cases following, but that court really said predictive coding can now be considered judicially approved for use in appropriate cases. It wasn't saying it's right for every case, but in the right case it would work. So following that, another significant case was Dynamo Holdings, and in that case, the IRS commissioner sought to compel production of the contents of backup tapes that contain several million records. And what it objected to was the producing party's request to use predictive coding to review them. And the IRS commissioner said this was unproven technology. And that position was rejected by the court, which said really that the substantial judicial and industry acceptance of predictive coding in the U.S. Was clear, and it emphasized the discretion that producing parties have in conducting document review. And it said, why is this even before the court? Because the court really shouldn't be in the business of dictating to parties the process that they should use when responding to discovery. And to me, it's a really interesting question. We talked about it a bit in the last session about transparency, and do you need to tell the other side that you're going to be using predictive coding, and how important is that? And I think that's where these U.S. cases have really arisen, where one party has gone to the other side and wants them to bless the fact that they're going to use predictive coding. The other side says, "Whoa, hold on, we're not sure we're comfortable with this technology." I think that in a lot of cases in Canada right now, there are very open discussions at discovery plan negotiations about the technology that parties are using. In other cases, less so, and producing parties are saying we need to get to an end result, and as long as we develop a process, as long as we adopt it consistently, as long as we validate that process, we don't have to disclose that to the other side. So I don't think that there's a right or wrong there, but it's certainly interesting to have a court saying, this is really none of our business, and parties should be able to, pick the process that they want. In the Rio Tinto case, the court approved the parties' stipulation to use predictive coding and offered a little bit more guidance on it. And most of the decision was discussed the merits of transparency and cooperation in developing predictive coding seed sets. And the court, though, in that case did say that it was now in the U.S. black letter law that parties can use predictive coding. So I don't think we're there in Canada, where we've not yet had a court say that this is black letter law and we can use predictive coding. And it will be, we look forward to the day when we do have that decision in Canada. The EORHB case, a little bit different. In that case, one of the things the court had to weigh was whether predictive coding made sense financially and whether the cost of it was appropriate. And it was determined in that particular case that predictive coding was not necessary, as the number of relevant records was expected to be small, and the cost of actually using the technology outweighed the benefit. And then just briefly, moving on to our the UK case law, that's been really interesting. So this, in 2016, we've had UK courts saying that the cost of manually searching documents in that case would be several million pounds at least, whereas the predictive coding exercise that was sought was estimated to be much lower, I think, a fraction of the cost. And the master in that case concluded there was no evidence to show that the use of predictive coding software led to a less accurate disclosure, and said that due to the cost savings and the size of the claims, it was suitable to use predictive coding. There's another newer case, which is the David Brown case, which is currently unreported, but I mean, we've been reading a lot about it, but don't actually have the court case. But in that decision, one of the lawyers contested the use of technology, concerned about the accuracy of it. The registrar in that case ruled in favor of predictive coding because it would reduce cost, and actually accepted the argument that it was more accurate than the human review process.
Susan, you said there's no case law in Canada yet, but do you know if firms in Canada are using this technology?
Absolutely, because we are working with several firms that are using this technology in different types of cases. And in some cases, as I mentioned before, we're having the discussions and both parties are acknowledging and accepting that that's how we're using the technology. Another time that we're using it is when we're getting large production sets from opposing counsel. So we've got 1 million records that have been produced to us. So it's not our records where we're using predictive coding, but we're using it to analyze and look for the key documents in the other side's production and to prioritize the review. So we're using it regularly. In that case, we're using TAR regularly in those types of cases to help us find the key records. So now to kind of bring this to something that you can get your heads around and talk about actual case studies where we've used predictive coding. I'm going to walk you through a couple of cases that the firm has worked on. And these were cases where we used machine learning, so they're quite interesting. It illustrates, the results and the process that we adopted. So in the first case, we had 420,000 records, and this was post-deduplication. The client had already developed a sophisticated set of keyword searching and date filtering, so they were confident that the collection was culled down as best as it could be using keywords, but there were still 420,000 records remaining for review. Like every other client that we have, they were concerned about the cost of the project going forward and actually having to review 420,000 records. So the first step that we did, and the first thing, was relatively easy, and we removed what we called redundant emails. And those are sometimes, depending on what tool you're using, they're often called different things, but non-inclusive emails is another term. Basically taking the emails within longer email threads and removing the various repetitive emails. What remains is the longest email in the thread, and you exclude the redundant emails. In doing this, of course, you have to be alive to the fact that some of the emails go off into different threads, some of them have attachments, those have to remain into the review set, but it's really the ones that are clearly redundant that are excluded. And in this particular case, of the 420,000 records, that allowed us to remove 64,000 records, and we were then left with 356,000 records for review. We had, in that case, a seed set of 610 relevant records that had been identified by a subject matter expert who was, as Chuck mentioned earlier, preparing for the case and preparing pleadings and reviewing documents. So after the seed set was collected as a separate exercise, we had the review team sample random records from the collection to determine which ones were relevant and which ones weren't. So what Chuck said is right. We start with the review right away. So we train the review team, and they can start looking at the random sample of records. The purpose of that sampling was to allow us to predict how many records in the collection would be relevant. So they reviewed that sample set, and the prediction came out at a very early phase that we would have somewhere between 68,500 and 79,000 relevant records. So we knew out of the 356,000 records for review what we were looking for. So of course the goal is, how can we review as few records as possible to find those relevant ones? So once we were done the sampling exercise, we began the review, and based on the seed set, the machine learning system began to look for similar records so it could prioritize those for review. Based on the seed set, it created batches of likely relevant records. What was so interesting about this process for me was, at the beginning, we were getting extraordinarily high relevance rates. And I have to say, I was worried, because I thought, oh my God, we've got 90% relevance, and we're going to have to review all of the 356,000 records. Quickly, they told me to relax, not to worry. This would all work out in the end. So we continued to go through the process. And after reviewing 189,000 records, we were getting feedback from our review team, and we were looking at the collection. There was nothing left that was responsive. So our reviewers communicated that to us. We could see that from pulling our daily results. So at that time, we reviewed 189,000 records. 71,000 records had been found, which was exactly within the number that was being predicted after the sampling at the outset. That's somewhere between 68,500 and 71,000. So maybe we were done. So we obtained instructions from the client, and we took another validation sample of the remaining records to determine if any further review was required. And the results of that validation sample were that less than 1% of the remaining records were relevant, and then a decision was made by the legal team to terminate the remainder of the review. So the result was that by using the TAR process, only 45% of the 356,000 records were reviewed, and that enabled us to find over 99% of the relevant records. So that's a pretty good result for the client in that case. Moving on to case study 2. In this case, we were told at the, I'm just looking, there's a couple of questions here. I'm looking, okay, this is helpful. thank you to one of the people who's watching, just to say that there is an article on the Competition Bureau, which actually I am aware of that, about using technology and how the Competition Bureau has allowed document process with predictive coding. And so we will put up on a link to that. It's a case study that FTI did. So we'll put a link to that up if anybody's interested in that as well. So going back to case study 2, in this case we had been advised that there were over 6.5 terabytes of data. And although no one knew how many records that was, we estimated that that could be in the range of over 50 million records. So something that was way beyond what we would want to have any type of traditional eyes-on review. The cost of that would be astronomical. So we knew we needed to develop another approach. The first thing we did was we had very focused custodian interviews, which allowed us to go in and conduct a targeted collection, and that resulted in only 875 gigabytes of data being collected instead of 6.5 terabytes. So you can laugh when I say only 875 gigabytes. It's still a lot of data, and resulted in 3.2 million records being collected. So again, not an insignificant amount. After deduplication and date filtering and culling out other non-user files, the 3.2 million records was significantly reduced. So we went down from 875 gigs to about 600 gigs of data and 1.4 million records for review. Again, reviewing 1.4 million records was still going to take too long and be too expensive for the client. So we opted with going with a machine learning exercise. So at the outset, what we did in this particular case was we removed the 44,000 records that we identified electronically were in a foreign language. And we knew we did that at that stage because we knew it would be too difficult to do the machine learning exercise simultaneously in 2 different languages. The client had made us aware at the outset that there were going to be a lot of foreign language records. We then took 5,000 records that had been reviewed by a subject matter and used them as the seed set. At the same time, again, we also conducted sampling exercises, which in this case predicted that within the 1.4 million records, 48,500, somewhere between 48,500 and 77,000 relevant records would be found. So in this case, clearly there was a much lower percentage of relevant records than in case study 1. We then proceeded to use the machine learning to create batches and condense the review. Again, at the beginning, high relevance rates of the batches, but after approximately 280,000 of the 1.4 million records were reviewed, 62,500 relevant records had been identified, so we were within that sample range. We got to a place where our team said they were seeing very, very little that was relevant. Same process. We went back, got instructions from our clients to stop the review and conduct a validation sample. That was done, and again, we had less than 1% of the unreviewed records were deemed relevant, and therefore we decided to terminate the review. And in this case, the result was really significant. Using the targeted collection, only 13% of the available records were collected, and then the TAR techniques allowed us to review only 9% of the collected records. So the 3.2, that's of the 3.2 million records. And by reviewing that 9%, we were still able to identify over 99% of the relevant records. So we would argue that's a very, very reasonable result and certainly legally defensible. And we talked earlier in our previous webinar about proportionality. Proportionality, clearly, we would argue that was a very proportionate result. And it worked so well because our clients were comfortable and they understood the process and they knew that they could, when they were stopping the review, that we had validated the results, and we could say not just we've got somewhere in our range, and we've got 62,000 relevant records were within our range, but we also were able to clearly say less than 1% of the remaining records would be relevant. So think about that. There were 1.1 million records left for review. So the cost of reviewing 1.1 million records to find that 1% would be completely disproportionate.
Susan, even though you found less than 1%, did you actually look at those records to see whether they were really relevant or whether they were just marginally relevant?
We did, of course, and found that they were on the bottom side of marginally relevant.
So that played into your decision to end the review.
Absolutely. So they were barely marginally relevant. I would say tangentially relevant. So and we're talking about less than 1% and 1.1 million records. So we actually looked at those records because there were so few of them and said we are completely comfortable with terminating the review, the eyes-on review at that point. So now I guess the big question is what's going to happen to all of us lawyers in 5 years? Are we going to see all of this technology replace us? And are these computers and all these tools going to be replacing the work that we do?
Well, this is where I think I'm going to have the most fun, because I like talking about how smart or how not smart computers really are. When I started working in computers 35 years ago, there were dire predictions at that time that within 10 years, everyone's job is going to be replaced by computers. Even 5 years ago, when TAR started being applied to legal work, I heard the same predictions again. And every time I hear those predictions, I laugh. Because computers are excellent machines that can perform repetitive work millions and millions of times faster than humans. But despite what you may read in science fiction or watch in science fiction movies, computers do not think. They don't reason. There's this thing called artificial intelligence. And the important word in that term is artificial. It's simulated human reasoning. It's not real reasoning, and that's the key to remember in all this. Computers are programmed, and they can be programmed to do all kinds of things. And because they're processing these programs millions of times faster than humans do, it may look like they're actually thinking. And to put this into context, a computer can be programmed to understand that a fire is hot. You can hook up a temperature sensor to a computer, and you can program the computer to tell it that if the temperature sensor reads 40 degrees or higher, then that's hot. And if the computer has an arm attached to it, you can program it to say, if your sensor tells you that it's above 40 degrees, don't stick your arm in the fire. Okay? Now that's just simple programming. A human, on the other hand, knows that a fire is hot, and they know if they stick their hand in the fire, it's going to burn. The computer doesn't know that their computer hand is going to burn. All they know is that the programming says don't do it. If the programming says that the threshold is 4,000 degrees, then at 40 degrees it'll stick its hand in the computer and be blissfully unaware that it's burning its hand, because all it does is follow its programming. It doesn't actually think. Having said that, computers are going to replace some legal functions. And basically, computers are going to replace legal functions that are very easy to program into, or not necessarily easy, but able to program into computers, things that are repetitive. Things such as legal research, due diligence examinations, and drafting straightforward legal documents. A few months ago, Deloitte released a study that they did where they estimated that 31,000 legal jobs have already been lost to this new technology, and that another 39% are at risk of being made redundant. Some of the systems that are already in place that are replacing legal functions are things such as legal research. There's a company called Ross, and this has been in the news several times in the last 6 months. It's a system that takes advantage of the IBM Watson computer. And if you ever watch Jeopardy, you may recognize the term Watson, because it's a computer that went on to Jeopardy a couple of years ago and beat a couple of 5-time champions. And so they've taken that computer system and they're now applying it to legal research. The lawyer can type in a plain English statement saying what they're looking for, And the ROS system, which has indexed millions and millions and millions of citations, will go out and it'll be able to interpret what the lawyer has typed in and be able to return accurate legal research. This system has the backing of Dentons. They've set up a legal technology division, and it's being used by Baker and Hostetler in the U.S. for bankruptcy research right now. There's a law firm in the U.S. that's using software called TermFrame that reads and analyzes clauses in loan agreements. It helps the lead lawyers through transactions and points them towards the correct precedents to use in their agreements. There's another system in the UK, Verifi. It's D-E-R-I-F-I if you want to look it up. And it's used to sift through European regulatory registers to check client names for banks. And finally, there's another system currently being developed in the UK that's designed to assess at the outset the merits of personal injury cases. And so you can see that the technology is being applied to a lot of functions that are traditionally being done by associates and clerks and articling students. But none of this technology is being developed to actually develop legal strategy, and that's really where the difference is always going to be. Computers don't reason, computers don't think. All they do is follow a set of programming rules.
Well, and I think that we should be using all of this technology to assist us as lawyers, and that's how we use it. So I'm not worried that it's going to replace us. I think it supports us and helps us do our jobs actually better. So, you know, for example, we're using predictive coding and other tools to help us find key documents in large data sets. So we've been working with recently on a couple of projects with clients, and I mentioned this earlier, where they get a large production set, so it's several 100,000 records, and they don't have the resources, and they don't want to spend tens of thousands of dollars on a review. They want to sit down in front of a computer and use conceptual categorization, for example, to help them find records that are key, or they want to use the technology to help prioritize sets of documents for them to review in the large set, so that they can be looking at the key records first. So it's really and going through any of those exercises, we can't just throw the technology at it. What we really need to do to go through those exercises, we need human intervention. We need the lawyers who understand the case, who know what they're looking for, to be working with us to help us identify those records. So it's not replacing the lawyers, it's supporting them. So just to sort of start to wind up, and we'll leave a few minutes for questions at the end. I'm going to turn it back over to Chuck just to talk to you about some of the resources. And I had mentioned early on Sedona Canada Principle 7, and Sedona Canada principles were updated and revised and released in 2015, and have been endorsed by the courts as a best practice guideline. So that's our sort of, for now, endorsement and for using technology-assisted review. And then Chuck's going to talk to you about some of the other resources that are out there.
And in the 2015 revision of the Sedona Canada Principles, Principle 7 in particular, the commentary associated with that was significantly updated, because over the course of the 4 years between when the first edition came out, the technology changed significantly. And I can see within the next couple of years it's going to need updating again, because technology is continuing to change and become better, and it's important for the legal industry to stay up to date with it. Another good resource, as always with anything e-discovery related, is the e-discovery reference model, EDRM. On that site, particularly related to TAR, there's what I think is a pretty good paper on statistical sampling that delves into a lot of the stuff that we touched on. It talks about survey sampling, assumption sampling. It talks about confidence interval, confidence levels. And it would be a really good document for you to read. There's a glossary of technology-assisted terms that two people who have been very heavily involved in this have put together. Professor Cormack, who's a linguistics professor at the University of Waterloo, and Mara Grossman, who's a lawyer at a firm in New York, have teamed up to do a number of research papers and research studies on using technology-assisted review in the legal industry. They've put together this glossary, which is really good because a lot of the terms here are acronyms, and it's always hard to remember what the acronyms stand for. I usually just make it up on the fly. They've also put together a really good paper that talks about comparing using technology against manual review. And essentially their conclusion is using technology is definitely not any less accurate than doing a manual review, and in some cases is even more accurate than doing a manual review. And I would really encourage you to download and read that article. There's other articles on that same site by Grossman and Cormack that talk about more advanced technology-assisted review techniques, and in particular, what's now some people are calling TAR version 3, which is a modification of the machine learning routine that we've talked about here, where you don't even start with a seed set, you just jump right into the review. And there's some debate on whether it works or not, and it's still, the jury's still out on that.
And I think this discussion about whether technology-assisted review is more efficient than manual review is sometimes really important, both in terms of educating your clients and in terms of educating the court. Because you've got to be able to, if you're going to be educating a court, you're going to be trying to convince the court that it's okay for you to use these systems, you've got to convince them that it is more efficient. And then they have to, I mean, and you think about it, and they have to sort of accept that there are always going to be errors with manual review if you've got people sitting and reviewing, you know, tens or hundreds of thousands of records. And this study, you know, this article is very helpful to educate people about that.
And finally, I've posted this link, the top 10 concepts understanding of predictive coding. It's a really well-written article that explains in simple terms some of the, or all of the technical jargon surrounding predictive coding. And although I've tried to explain it here, downloading that and reading that will just reinforce what we've been saying. Now, there's a couple of questions that we still have time to answer. And if you have any more questions, please ask us.
So here's I'm gonna answer one of them, which was, why do lawyers in Canada seem slower to use TAR than lawyers in the U.S. and the U.K.? And I'm not sure we know that that's the case or not. What we do know, I think, in all three countries is that it's a very, very small number of lawyers who are actually using TAR. So if you go and and even when I'm talking to American lawyers about this, which I do all the time, it's the same lawyers who are using it. And you know, there tend to be at, you know, certain firms that have adopted the practices and have the tools in place and have, you know, good, strong litigation support departments. Those are the firms that are using this technology regularly. But by no means is it across the board, and there are thousands and thousands of law firms in the U.S. that aren't using this technology. So I'm not sure how far, you know, behind we are. And I think we're using technology-assisted review in Canada in many different ways, whether it's through keyword searching, email threading, people are using all the time near-deduplication software to group together similar records. We see lawyers in Canada using that all the time as well. So it's really, I think that it's really the predictive coding and the machine learning piece that is new to us in Canada, and I think it's as new to people in the U.S. and the U.K.
And you might want to compare Or think about the number of lawyers that are actually using e-discovery software compared to printing out and still reviewing by paper with little stickies their documents. And there's still a lot of reviewers, I mean a lot of lawyers who are printing out documents. When we encounter it, it blows our minds. Why would anybody waste their time doing that? But there's for some people, there's just an aversion to using technology, and it may not even be a rational aversion.
What I'm hearing now more though than the actual printing of the emails is lawyers saying, I got a USB stick, what my client sent over, their mailbox, and I've got all the PDFs, and I'm just going through them manually one by one, and that to me sometimes isn't any better, because they're going through them one by one and they haven't sorted them and they haven't put the nearly duplicates together or the email threads. So you've got 3,000 emails on a USB stick. You want to be able to use the technology and only review 1,000 as opposed to 3,000 if you can pull out redundant emails and exact duplicates. And when you get that data just sent over directly from your client, that information is generally not well organized and not well sorted. Whether you're looking at PDFs or whether you're looking at native files, whatever the format is, they're generally not well sorted. And so that's why you want to use these tools, so that you can improve that process and make it more efficient.
All right. Well,
I think we're out of time now, or approaching 9 o'clock. So if anyone else has any additional questions, one thing that we haven't talked about specifically are the actual tools that we use and the products that we use. But if anybody has any more questions, feel free to email either me or Chuck. Chuck's email is not on this slide, but it should be. It's crossman@workmans.com. And so you can, I think it's on the front of the presentation, so feel free to contact either of us with any additional questions. So thank you so much for joining us today.
Thank you. Bye.